As your lordship, 14 days we have prayed it. Your lordship, I am leaving to your lordship. At least, he will attend the marriage.
Marriage is on 3rd September.
3rd September, that's it.
Day after.
Yes, day after. Because with this application was
1 week is sufficient.
At least,
You will be released tomorrow. You will attend marriage day after, and then
after I am leaving to your lordship.
Performing Kanyadan, whatever ritual.
There I want to meet also.
If at all sees your adoption.
It's a long time. I am in custody. At least I would be able to meet the other relatives also.
15 days. Shall we produce with the usual order? For the trial court latest writing order. And in case Madam Kalam undertakes to get the order, do report. So upload करना है आज ही.
Regular bail after filing of charge sheet. Date of arrest is June 2024, 26th of June. Out of 6 accused persons, 3 have been already released on regular bail. Of accused having exactly identical.
What is the nature of antecedents?
They are also very similar nature. On last week, same accused person was released on regular bail, my lords.
Notice.
Please, my lords. Some returnable date I may request.
Date will be there in this court always. There is
my lord. That's
permission to serve the screening.
That is also there part of the order.
Oblige.
For the petitioner, this is a fresh matter. Well, it's 6 months in custody.
What is recovered?
Well, the allegation is
what
that
is recovered
smack is recovered. The allegation is that smack is recovered of 48 grams. The main accused has already been granted bail.
You have antecedents.
Malaz,
under Gangster Act, under NDPS.
Malaz, there are 2, I have disclosed that in the synopsis, there are 3 antecedents, Malaz, in which he has already been granted bail immediately after.
Granted bail, it is pending, not admitted.
I understand, Malaz, he comes from a humble background, Malaz, and the main accused has already been granted.
Smack, is something. Smack and this is commercial quantity.
No, Malaz, commercial quantity is 250 grams. He has been, the allegation is 48 grams, Malaz. It's lower than the intermediate quantity.
480 grams or?
No. Malaz, item 63.
101 grams.
101 grams is the total, Malaz. The main accused is 52 grams. I am 48 grams. Main accused has already been granted bail.
Will you should notice why should that bail be not cancelled?
Malaz, this is a very poor family, Malaz. I have personally met the family.
Okay, fees is
Malaz, this is a pro bono matter. This is my first appearance before your lordship.
Why are you doing pro bono to an NDPS accused?
Malaz, it's a very poor family. I personally met.
Nobody does pro bono for an NDPS accused.
I am making a submission.
We were also on that side.
But it's a very.
We were also on that side. And if your definition of pro bono is not less than 1 lakh, then we don't know.
I'm making a responsible statement that this is a pro bono.
No, business. Sorry, there no.
Because the co-accused has already been granted.
Thank you. Antecedents. It is not that co-accused. Antecedents are also there.
Malaz, please have the FIR with me just 1 minute.
We'll have it, no problem.
Just
tell us what you want.
Yes.
See, co-accused has been granted bail, recovery is from you as also the
Malaz, just the FIR for 1 minute.
How do you explain the antecedents?
Malaz, the antecedents, Malaz, my averment is that I have been framed, Malaz, wrongly. Just have the FIR
in relation to which offense?
Malaz, NDPS offense.
NDPS, same crime, same nature.
Malaz, just have
Thank you.
There's no independent.
Thank you.
Then Malaz may permit me to withdraw them.
Okay, withdraw. So, उससे fees बढ़ जाएगी?
Malaz, no fees, but it's
withdraw. Next case.
With liberty to approach the.
No. Milords, in this case, the only condition is local severities. Whereas I reside in Delhi, case is in Gurgaon.
So
my wife and my son is there. So I'm 73-year-old. Nobody local from Gurgaon is there.
Right.
That is the only request.
No.
I may be allowed to furnish the security of my wife and my son.
No. Local surety.
Milords, wife and son, Milords, actually he is 73-year-old. Milords. Nobody.
You are lucky you got the bail.
That is there, Milords.
That is there.
Milords, I am requesting only one condition. Amount may be same, Milords, but only
you are lucky you got the bail. We are telling you.
From Delhi to
Gurgaon. Next case.
Please. By the same order, my husband has been granted bail.
Unfortunately, why the court did not grant to you?
Just no reasons are actually assigned for non-granting bail. they just considered. There are multiple transactions between the parties, and if you lordship will see at page 28, there was a previous agreement. Previous agreement between the parties wherein I paid 6,05,000. And if lordship will see at page 30, I returned them out of 1,83,000. I returned 1,16,000. Case is completely of civil nature, and all transactions, there are multiple transactions between the parties.
Notice, yeah, interpret.
Great, great.
May I please note, the item 66 is a fresh SLP matter.
Yes.
The learned family court rejected the respondent's divorce petition and rendered a finding that all the evidence that has been produced with respect to cruelty and desertion, they do not stand a ground. Because the High Court doesn't disturb the
Patient.
Please, Your Lordships. Well, it's the High Court grants stay methods in view of the orders passed in first round of litigation methods. Well, it's a consequential order is under challenge methods. Well, it's initial round methods went up till this honorable court methods. My difficulty is methods. Well, these orders, well, this honorable court has rendered that SLP instructors in view of this consequential order, which was well subsequently challenged, which is under challenge before
This is
report.
the next date of hearing only, na?
Well, it's yes, Your Lordships are right, but
Go there and tell the
Your
court.
Lordships, my only requirement, well, Your Lordships may only clarify, well, the orders that were passed in first round, well, because the SLP which has travelled up till this court, well, was rendered instructors in view of consequential order. That consequential order, well,
We are
is
not
now.
clarifying anything. What is before us is not that previous history. What is before us is this order.
Well, please give me a minute. Well, Your Lordship will see the writ court order, well, for a minute. Well, the writ court, well, relies upon.
Kindly come to page 2.
Well,
What is the order and the challenge before us?
it's why I am here before Your Lordship says. Well, that order before this honorable, when the SLP in the first round travelled up till
What
this.
we are saying is, sir, what is before us?
Well,
Is this an application of MA in that order?
Well, that MA was filed, Your Lordship, sir. Well, dismissed that MA. Well,
Garlic matter.
Garlic matter. Well, that MA was dismissed. Well, my difficulty is, well, this order is coming in my way. Well, this writ for R1 is, well, empty formality. They'll refer to division bench judgment.
We don't know what they will do. We don't know what we will do.
Well, then I'll be suffering. Well, a lot of farmers, well, those who will suffer. Well, they have been charging commission wrongly in the matter. Well, it is not permissible.
In the nature of an interim order, interim order is in the nature of interim, in time.
Your Lordship may only clarify that, well, order passed, they cannot be referred. Well,
These minutes. This is an ejectment against me.
Who are you?
This is an ejectment
Who are
against
you?
this petitioner.
Oh, you are a petitioner, we know that. You are the landlord.
I'm the teenage millets.
You are the litigant, okay. You are the tenant or the landlord.
These millets, I'm the teenage millets.
Correct.
Concurrently.
But the short point is the this ejectment petition was filed on the ground that there are two shops, and one of the shop he cannot use, and the other he wants to use, where I am being based millets as a teenage millets.
Fees
I'm a poor developer.
फीस आ गई आपकी कि नहीं?
These millets.
फीस आ गई, ठीक है. अब हमें बताइए कितना टाइम लेंगे आप खाली करने में?
Millets 2 years, please.
हाँ.
Then whatever falls from this honorable court, I'll accept them.
You tell us, be reasonable.
Millets at least 1 year be
No,
given.
there's no question. This is not a halwai shop which is.
Millets, I understand, but he's a poor developer. Millets, he has been staying there for so long. Millets, at least 9 months be given.
Okay, ठीक है, 9 months.
So great.
Then undertaking.
So great. Millets.
My lord, I beg to appear for the petitioner.
Yes, sir.
My lord, the impugned order is devoid of consideration, is devoid of jurisdiction. I take my lordship to page.
Who are you?
My lord, I am the father. My lord, in a transfer petition filed by the father, my lord, an order is passed, give the custody of the child whom she abandoned 3 years ago, in between an academic year. Kindly take.
We are issuing notice.
Yes, sir.
We are issuing notice. We'll give a short date.
Yes, sir.
We'll explore the possibility of settlement also. And today the custody is with you.
Yes, my lord, a contempt has already been initiated.
If your honor permits, I request to take notice in this matter, your honor.
Yes, ma'am, you're there.
Yes, your honor, during 4.5-year-old,
We are only asking you today, the child is with whom?
It is a
with the father, your honor.
Correct. So therefore, till the next date, let the status quo be maintained as it is. You file a reply and come see whether there is any possibility of settlement. Is there any possibility of settlement? We can
The- the
refer to
ma-
mediation.
The matter was referred before the High Court only for settlement, Your Honor. They are not ready for settlement, Your Honor.
Okay,
Since the
today,
child was 4 years
are
old, they
you-
have kept the,
just 1 minute.
yes, Your Honor.
We are trained mediators now. You, by virtue of our experience, we have become trained mediators. All of you, both of you remain present in court. Let the parties remain present in court on dash. Meanwhile, the state operations.
Any short date, Your Honor?
Short date will be, you tell us tomorrow?
Your Honor, a week's time, Your Honor.
Okay, weeks. We'll reassemble at 2 o'clock.
Let the child be brought, Your Honor.
Thank you. Yes, please.
So that just hand over.
Availability tomorrow day after.
Problem is constitution bench.
No. Today also there is no CV.
So today is no CV. Luckily, there is no CV.
Because tomorrow now our bench constitution is also changed.
Oh, I see.
So we'll have to now find out time to finish this.
The gossip will then fix it on a date and what.
So we can hear you today or what? No, two things are crossing our mind. Either we hear you today because we have leftover matters, finish that and then take it up. How much time would you take? We just wanted to know.
Take a bit of time.
No problem. How much time this side? Now we put for the day.
Arguments are concluded. Now he took a little more time to add. Look, the Lordship was kind enough to hear all parties out for quite a long time.
At the time, each one of you exhaust your breath.
Now it depends on how long does it take.
Not stop.
If it doesn't open the case,
It's better give it in a day when we can be heard, mothers, at length, instead of being pressured by this. That's better.
CV is any tips?
Manoj, what we can do, I'm suggesting it, that the CV, I will be arguing on Tuesday and Wednesday. And then you can fix it next week sometime, others.
What?
yes, next week we can get according to our program also.
Yes, what we'll do is,
Yeah,
next week we fix this matter on Monday
very good,
at 2 p.m.
very good.
If this bench is sitting, then we can have it earlier also.
Fine.
If this bench is not sitting, then this bench would be.
Fine.
Similar.
That's fine.
Would that
Very well.
Then give us the afternoon, Manoj, so that it can be okay.
We appreciate it.
There is also 24. My notes.
Being it on 8.
Monday.
And my lords, we're grateful for that chunk of time because there are some new points that have been raised that we will just address briefly.
The main is puff up our lungs at so that they are
You have said the time.
we try to puff them up.
He's trying to say we will exhaust ourselves outside partially, so that we
So as not to exhaust my lords.
Yeah, I've just circulated this, maybe your lordship should react to.
List on Monday.
Good Manoj, Mr. Gopal Subramaniam was also there, Manoj. He's not there till the 10th, Manoj. Any date after.
No problem. On Monday we'll accommodate him.
Just that small amount.
Let's start at least, let's start at total. There's no CV, so Mr. Subramanian. No.
Monday.
Let Mr. Sival complete the argument, then we shall see how we can manage our time.
Subject to the permission of Honorable the Chief Justice. Matter be listed on Monday at 2 p.m.
Details.
It's 8. Monday means 8.
Yes, Monday is the 8th, yes.
Yeah, keep going.
Flash.
Not Mr. Sibal. Has this been uploaded?
We'll upload.
They are just upload.
Ah, we'll upload.
Also,
But we have
But just upload it.
Sure.
this comprises all our.
Thank you. सारी फाइल मैं आपसे पहले बोल रहा था कि हमारे item
I'm seeking a short accommodation for 2 days.
70 0. What is it?
I'm seeking a short accommodation, madam, for 2 days, madam. And arguing also is out of India, madam.
How? What is the matter? Let us see.
Is it 302?
He was discharged by the High Court. The High Court has set aside. He remanded the case for a fresh trial. The fresh trial. That's all.
On his request, when do you want?
My lord, Wednesday or Thursday, madam. Wednesday or
Thursday. This coming Thursday.
The report also indicates that similar matters are pending. The order is at page 63 minutes.
Yes.
Same order. Same FIR. And same
Yes. ये जो पेज 63 वाला ऑर्डर है वो पास कर दीजिएगा, टैग कर दीजिए. Just one miss call one.
With the criminal case number, I'll give you the court master. That will have to be changed.
Give the case number. ये पेज 63 वाला जो ऑर्डर है वो ये होगा केस नंबर ला.
Item 73.
Yes, please.
My lords, may just have looked at 2 pages, my lords, before going to the impure judgment, my lords. First, may I have looked at page number 30.
Yes, please.
This is, my lords, the circular dated 7th of December 2001. My lords, may permit me to read only the first paragraph. I am directed to state that the proposal for providing incentives to the group for scientists in order to attract, retain, inspire, and motivate scientists to give their best contribution on the pattern of the same being given to the scientists in DRDO, as per the conference given by the Minister of Finance, was placed before the governing body at its 150th meeting held on 15th February 2001. The governing body considered the matter and approved to grant the following incentives to group for scientists in CSIR with effect from 1/1/2001. Now, madams, may kindly see the very first paragraph. Special pay of rupees 2,000 per month without DA to scientist group 4 in the pay scale of so and so in lieu of a separate higher pay scale after peer review. But this peer review, my lords may take note of, took place later, but the higher pay scale was given only to the scientist in DRDO and Department of Space, but not to the CSIR. Now, my lords, may kindly come after this order. The next page, my lords, may have a look at is page number 33. And in this, my lords, may kindly permit me to read only the paragraph number 1.
Yes.
All the existing scientists, as well as those who are promoted, recruited in the scale of a pay of rupees so and so, will be, this is, my lords, the grade 4 scientists, will be automatically entitled for the special pay of 2,000 rupees without DA. The special pay will be, my lords, may kindly note, the special pay will be entirely a separate element, not to be taken into account for any purpose, such as pay fixation, entitlement for various purposes, and specifically mentioned pension, etc. Now, these orders are up, this is up to 8th March 2002. Kindly take note of the date, my lords, at the bottom, CSIR circular, 8th of March 2002. 2001 clarified by the clarification dated 2002, continued in operation till the year 2022. People balance derived the benefits, the benefit of special allowance on the basis of this office memorandum, on the basis of this circular, accepted the benefit taken till 2022. Some officers come and they challenge it before the tribunal and say that we are entitled to the benefit of a judgment in the case of OP Nijavan, where the incentive was in lieu of a higher pay scale. Whereas in this case, the incentive was only an incentive. It has not been replaced by any higher pay scale. And it, both the tribunal as well as the High Court merits are mechanically followed.
Where is the stand before the tribunal?
That
This stand, which you are taking, page 33.
Page 33. These are all part of the record matter.
Here is your pleadings.
But there is no pleading to the effect by the applicants before the tribunal.
By you.
Yes, madam.
There is a reply before the High Court.
Yes. That reply is not in the reply.
Before the High Court, you had.
But reply has not been filed here. If permit me, I'll file that reply.
No.
But the fact remains.
Gentlemen, just 1 minute.
Yes.
You filed a writ in the High Court.
Yes, madam.
Where is the ground in the High Court?
But that has not been filed.
Where is that ground? Is there?
My lords, they have not filed it.
I have not filed it.
We know they have not filed it.
Yes, my lord.
You have a copy of the writ here.
No, my lord.
We have it on a soft copy.
Have they taken this as a ground?
No, my lord, they have not.
Fresh case, my lord.
Yes, yes, madam.
No notice has been issued.
Even otherwise also.
So it was adjourned on.
My lord, Mr. Bala Subramanian was not well.
Okay.
Therefore, my lord, sorry.
You are there now?
Yes, my lord.
Accepts notice on behalf of the respondents.
My lord, just one.
Just one. What's your good name, sir?
My lord, my name is A.K. Behera, my lord.
Shri A.K. Mehra.
Behera.
Invites our attention to the circular dated 8th of March 2002, bracket में page 33, as also communication dated circular at page, what is the date?
Page 30, 7th December 2001.
December 2001.
Yes, sir.
7th of December 2001, page 30, as also 8th of March 2002. In support of the submissions that what was accorded to the scientists was a special pay not to be taken into account for the purposes of computation of pension.
Yes.
Correct?
Yes.
Yes, sir.
And this was, my lord, accepted by the respondents for all these years till 2000.
That doesn't matter. Whereas in OP, whereas this court in 2020, volume 14, SCC 420 was dealing with a case where
my lord, this special pay was in lieu of a higher pay scale.
Special pay was in lieu of
a higher pay scale.
Higher pay scale.
Yes. Whereas in my case, my lord,
hence the High Court erred on relying upon the ratio laid down in OP Nijavan Supra. That's your contention.
Yes.
Notice, then reply within 2 weeks, rejoinder 1 week. The petitioner is at liberty to place on record copy of the pleadings.
My lords have issued notice. I don't know, I can't oppose it now, but squarely covered by OP Nijavan. In fact, my lords, he's made a wrong statement before, my lord.
He's made a wrong statement, then he'll suffer the consequences.
Even factually, on page 30, my lordships, even in this case, it is in lieu of higher pay scale. OP Nijavan has squarely covered it. In fact, my lordships can just have a look at for a moment, page 30. My lordships can look at Roman 1. In lieu of separate higher pay scale and peer review. And this is exactly covered. Can I just make exactly covered by OP Nijavan. Secondly, my lordships, his prayer before the Honorable High Court, our prayer before the Honorable High Court even before CAT was only with regard to.
We were wanting you to show us that you did.
My lords, 96 people have been given. On parity is what we moved this petition. This order is here. And this order waited for OP Nijavan to come up. So today they can't create a confusion before my lordship.
That's in this matter, where my lord can say in lieu of the separate higher pay scale after a peer review. In this matter, no peer review took place, only in the case of DRDO and Department of Space.
Yes, yes. I'll place it otherwise. There is nothing in this matter, my lord. Just one second. Huh?
You have
page number 72. Page 72, the writ is also there, my lord.
Nijavan Mallards is annexed to
whether in Nijavan also.
Yes, my lord.
After this similar notification, the circular of 7/12/2001.
Yes, my lords.
8/3/2002 clarification.
My lords, Nijavan.
There in Nijavan also.
Yes, my lord. I'll just explain, my lords. What happened?
Gentlemen, we are asking this Nijavan.
Yeah, but this is at page number.
Nijavan has been annexed, my lordships.
At page 40, my lords.
40.
And my lordships, this issue which crops up in this particular case has been dealt para 33 onwards, page 54 of Nijavan, my lords.
No, this clarification.
Yes, my lord.
Was available in Nijavan also?
No.
My lords, even I'll just explain, my lords, just what was before Nijavan, my lords, before this honorable court, was the issue was whether any special pay has to be added with pay for the purposes of pension with regard to the fundamental rules 925, what was being interpreted. There also, my lordships, what this honorable court did was it held that look, as far as special pay is concerned, if it is given in lieu of higher pay scale, then effectively it would be counted for the purposes of pension para 33 onwards, right up till 37, this has been dealt with squarely. Now, this issue has been dealt with. And in fact, 97 people from CSIR have been given this benefit.
36.
1 minute, gentlemen. There are 23. Similar notification.
Yes, my lords. Page 50, para 23, identical notification, my lordships. In lieu of separate higher pay scale after peer review. My lordships can see it's called out 3rd February 1999. And 96 people from CSIR have been given this benefit, my lordships.
Where is the similar clarification?
My lordship, page 20, para 23, page 50, Nijavan.
No, Nijavan is there.
Yes, my lords.
After peer review is also mentioned.
Yes, my lords. And in lieu of separate higher pay scale. Similar issue. Yes, my lord.
But thereafter.
Yes, my lords.
In our case, he is pointing out to the clarification of 8th month.
My lords, only a
similar clarification.
Only
was also in consideration.
There was no, my lords, there is some confusion being created. The only issue, my
it's not creating. It is a document.
No, I mean with the documents. Yes.
Query is very simple, Mr. Counsel. What is your name?
Vivek Chib, my lords.
Mr. Vivek.
Yes,
query is very simple. Para 23, we have seen that is a document at page 30.
Yes, my lords.
Was Nijavan also dealing with a document at page 33 is what our query is.
My lords, para 24, my lords. Just below that. Special pay will not be treated as pay for purposes like DA, HRA, etc., which led to filing of original applications in CAT, questioning the clarificatory order issued by Government of India. My lord, I am making a statement. This was squarely covered.
Then shows in the query only.
Yes, sir.
Yeah. See, either we are not understanding, then you can raise your voice.
No.
If we are understanding, we are. Mr. Counsel.
Yeah, Manus, kindly have a look at page number paragraph number 36.
We have
what
the page 50, para 23 and 24.
Yes.
Deals with identical communication, which you have invited our attention to at page 30 and 33.
Yes.
Now, tell us.
Now, Manus, I draw my lord's attention to para 36 of the same judgment.
Dismiss.
Obliged.
Para 36,
Thank
page number 55.
Thank you. Dismiss.
Item 74.
Obliged.
Lord, item 74 is a fresh petition I noticed there's no clarity in the SLP. I'm praying for 2 weeks' time to file an additional affidavit.
You withdraw it and file a letter with liberty. Seeks permission to withdraw the present petition, reserving liberty to file afresh on the same and subsequent cause of action with petition.
I'll do it. I'll do that. Grateful.
Liberty as grateful.
Please, Your Lordship. So both of them are living separately since last almost 40 years.
We cannot help you, sir. Only if you want to explore the possibility of settlement, that's the only thing.
Lordship may.
There's nothing in it.
Lordship may refer to mediation.
No. Today we have not even issued notice. How can we refer to mediation?
Some sort of mediation because she is living separately since last.
Only for exploring the possibility of only notice confined only for exploring the possibility of settlement.
He's ready for some one-time settlement. So I have taken.
Settlement.
Please. There is delay of 60 days.
Delay is no.
Lord, on item 76, on the last occasion, my lord had granted me liberty to file an additional affidavit. I filed IA. Along with that, I filed the judgment of the Rajasthan High Court. My lord, may kindly have page 15.
What does the judgment say?
This judgment says, my lord, that placement in the upgraded post will be treated as promotion and offset against entitlement against ACP, Assured Career Progression Scheme. And this judgment was in our favor. And at page 16, my lords have dismissed, I have placed the order of this honorable court. My lords have dismissed the SLP in my favor. So if I may straight away request my lords to have P4. This is the clarification which clinches the whole issue, my lord. P4 at page 127, my lord.
$120.
127, my lord.
Yes.
Starts from 121. My lord, may have 121. And the relevant clarification, my lord, is at page 127. Bottom, my lord. Serial number 31.
Why did we not issue notice?
My lord, because on the last date, I wanted to place the judgment of the Rajasthan High Court and my lord's order. That's why. Now I placed it, my lord. Although the office report stated there was some confusion, my lord, office report says SLP dismissed. But that was SLP dismissed in my favor.
That was an SLP of the private individual.
Yes, my lord.
Your Lordship.
So that was in my favor, my lord.
Your Lordship, in page D of the list of dates, they have referred to a judgment in the case of Bineet Kumar, Union of India versus Bineet Kumar. In that case, Your Lordship, the judgment of the Patna High Court clearly relied upon this judgment, Your Lordship. That was placed before the Honorable High Court, which is not placed before the before Your Lordship.
What we do is...
And Your Lordship, that judgment has been affirmed by this Honorable Court. The judgment in Bineet Kumar's case, SLP has been dismissed. Kindly see this. Page 36. Page 36, the judgment. I placed it before the Honorable High Court.
1 minute, 1 minute. You are respondent number.
I am for the respondents, Your Lordship, for the private respondents. Yes, Your Lordship.
Accepts notice on behalf of all the respondents. Sorry. She submits that
the judgment, Your Lordship, it starts at page 31.
1 minute.
Yes. Page 2.
Delivered by the High Court of Patna.
Page 26.
Page
26, Your Lordship. It starts from page 26. And the relevant is at page 36.
And delivered by the High Court of Judicature at Patna. Stands which in effect is in favor of the private respondents, stands affirmed by this court with the dismissal of the SLP. The SLP number is please.
And Your Lordship, page 36 clearly refers to this judgment. Yes, yes.
Whereas on the other hand, the NDAG submits that position to the contrary taken by the ratio of law contrary to that of the one laid down by the High Court of Patna stands laid down by the High Court of Judicature at Rajasthan. Bench at Jaipur in case number so and so. SLP arising therefrom preferred by the private respondents, by the private person stand dismissed by this court with SLP number so and so.
Stay over there. They have filed contempt.
1 minute.
And your lordship, also page 36, your lordship.
1 minute, ma'am, we are issued notice, we'll hear you.
Yes.
What we are doing. Please. Let the private respondents file reply within 2 weeks, remainder 1 week. In 2 weeks, in the meanwhile, no proceeding of contempt shall be precipitated by the private respondents.
Yeah, your lordship.
We stay the proceedings of proceeding in the contempt initiated by the
Grateful. Your lordship, at least look at page 36, your lordship, for a moment, your lordship.
You want
page 36.
You want us to dismiss it today? We will not do that.
No, your lordship will not. But
we want to see.
Yes.
2 courts have taken a different view. 3 courts have taken.
No, your lordship. There are in fact 4 high courts which have held in my favor, confirmed by this honorable court. And your lordship, it is not just a simple dismissal.
On the next day, it will be dismissed.
Your lordship, just 1 minute for my satisfaction. Yes. Page 36.
Yes. Yes, please continue.
Yeah. Further, CAT principal bench in OA number so and so again considered the same issue, and by order dated so and so, it held as under. We've heard both sides and have perused the material on record. The basic contention of the applicants is that they are squarely covered by the judgment of Chennai bench of the tribunal in OA number so and so. This order has been upheld by the Honorable High Court of Madras, and SLP file against the same has also been dismissed by the Honorable Supreme Court. The applicants have therefore prayed that they be extended the same benefit as was given to the applicants in the aforesaid OA. The respondents on their part have not denied the applicants are similarly placed as the applicants in OA number 335 of 2007. They have simply stated that OA number so and so may not be treated as a precedent since it is an order per imperium. In our opinion, this contention of the respondents cannot be accepted.
Thank you.
Is your lordship giving a big state for the
October.
Wait. On this matter, the Honorable High Court has observed that secretly recorded communication cannot be spied. The latest judgment of your lordship. Please. In that, so therefore, that is what I'm saying to the Honorable High Court.
No, that is between husband and wife.
Because in otherwise also.
No.
There were 2 questions.
No.
Because if I can,
it can never be.
Please, no, that's what. If I can.
Otherwise, government will privately record your conversation, and government will place it as evidence in every trial.
If I can only file
in every trial, there will be you see, even without you knowing, there will be a proof of conspiracy in every matter.
Civil case would be different. So therefore, what happened?
This was between husband and wife.
That was between husband and wife.
Yes.
But then also there were 2 questions.
These are civil proceedings. You record something in your pen. It is that pen camera matter, no?
Please.
You record something in your pen camera.
So therefore,
during mediation proceeding. And now you want that what conversation was recorded during mediation proceedings should be treated as evidence in court.
It was a panchayat.
Never be. Never. Mediation. Can never be.
So that judgment says
that is a wrong reliance on your part.
There are 3
that can never be relied. Private conversation behind the back of a party can never be treated as evidence. That too in a device.
Well, that's what was it. I can read the questions. But the question is whether a secretly recorded conversation can be permitted to be given in evidence. And then thereafter Because the first question was SLP kind of.
This 2005 civil suit, no? That
yes,
another
2005, but
another SLP, 2 SLP.
Yes, the other one rejected.
You got it adjourned.
Yes,
And the other one was received, absolutely nothing.
Plus, may allow me, 1 minute. Plus, if I can cite the judgment, only.
Yes.
Yes.
You can introduce me company offenses, these SOP is becoming.
But should be, that should be a offense while the petitioner is compounded before the trial court. If I may just pass on the order in the application filed.
Some settlement was going on?
Settlement was entered into. In the meantime, they've compounded the offences for the petitioner.
That's the end of the
Infructuous. This is infructuous. This is infructuous. Selfie is infructuous. It is already recorded or it is orders are passed
The
or?
order is passed. The order date is 25th of August on page 1, not sure.
Invite sir has placed on record order dated 25th of August 2025, passed by the court of passed by Judicial Magistrate First Class Ludhiana. In the order reads as under. We'll extract the order. Be of the same. He does not press the presentation. For the same to have become infructuous.
May I please, Milords? If Milords may recall, Milords had asked the husband and the wife to be here, Milord. The allegation is under POCSO. They got married at the very moment. And the complainant was the mother. So Milords had asked us to get them to the court. Milords, both of them are there. The wife as well as the husband's there, Milords. So Milords wanted to see Milords. We are praying for quashing Milords in this, Milords.
Trial, what is the stage of trial?
Milords, the charges were framed, Milords. Thereafter, there was a stay, Milords, and it has to start, Milords. She still has to give her evidence.
1 minute. Have we joined Ms. Ruchira? There's one behind you. You joined the bar? Shruti, you joined the bar? You with whom? Come forward. We request Shri Sanjay Jain, senior advocate, to assist the court as amicus. Just give your name and particulars also. Huh? Name, address, your name, your address, your email ID, your phone number. Shall assist the University Council. Huh? And also as amicus. Shall assist us. Then assist both the learned amicus and also us. Then the registry is directed to supply complete paperwork to the learned amicus within a period of in a digital form within a period of 2 days. Registrar Judicial shall ensure compliance. Then list on dash.
If I may request, Milords, then if Milords is
1 minute.
Sorry,
1
Milords.
1 minute. Shri Sharma submits that the Complainant, ये कहाँ से आया है?
गुजरात से।
But I opted for victim, R2 Milords.
Gujarat
R2,
Milords.
she's from Gujarat.
You appear for the girl.
Yes,
For this girl
for the victim.
1 minute.
from Gujarat.
You have verified their identity?
Yes, I am.
They have Aadhaar card and all.
Yes, yes.
Yes, Milords.
You retain it and
Milords, they may be permitted to join online if Milords for the next date.
Just you do one thing. You're in some matter here. Are you in some matter here? No. Just go out, talk to the lady. It's a case of POXO where they're remarried. Mother is the complainant. Go out, talk to her. Vernacular language. Ask her whether voluntarily she is, chosen to now reside with him or she is.
two things, whether she has married and whether the marriage is successful and still continuously staying with her husband out of her own free will. That two things.
Very well.
We just pass you. आप क्या करते हैं? किधर है दुकान?
He is running a shop of tire.
ठीक है, अभी थोड़ी देर में लेंगे आपका। आपका क्या नाम है मैडम?
Komal.
आप इनके साथ जाइएगा, बातचीत करके वापस।
Milords is passing it over, Milords?
Pass.
Oblige, Milords.
Item 80.
Yes, 80.
Your Lordship, pursuant to your Lordship's last direction, we have filed the additional documents with all the particulars, specifically the cases regarding the constitutionality which are pending. And if your Lordship may permit, I am praying for some time because there are aspects we would like to cover and research.